been a day.
It's been a week. It's been a very, very busy week. Okay, so we've had some interesting things happen, and one of the things that came up this week, we had a presentation and all of that, and there was an interesting conversation there, and one of them was about incapacity, and I remembered at that time that people don't quite understand what that is and when it kicks in and when it does not exist anymore.
Absolutely.
Okay, so in any estate plan that we prepare, we always make sure there are documents that will help take care of that person if they should be so ill they can't make decisions for themselves and they actually need assistance.
And that only counts when someone's alive, right?
That's true. Okay, so especially those powers of attorney, they're very powerful documents. They allow other people to take care of your finances and to make decisions for your health care. But as soon as that person dies, those documents are no longer valid. So anyone who thinks they're still an agent when a person dies is acting without authority. And yes, and it can be a big problem because that's fraudulent unless they have been appointed by the court to be an administrator of the estate of that person or the executor because that person had a will or some other documents.
These are all some big terms of art here that we've got going on. So we have power of attorney.
Right.
That's while someone is alive.
Right. And so what a power of attorney is I am giving another person the ability to act on my behalf because I am not able to do so.
And that can be financial or medical.
Right. And the financial one is very, very important. And so it's important that you choose someone that you're going to trust and you're not going to be afraid of what they're going to do or get into your bank account or your savings or whatever and do something that they're not allowed to do.
Right.
In which case
fiscally responsible.
Exactly. And not only that, they also have a high level of duty to the person who they're acting for, and they could go to jail if they actually dip into it and maybe treat it like it's their own. And so we want to exactly. So we definitely want to make sure that we choose people who are trustworthy. And then making those healthcare decisions. That's difficult for a lot of family members, but
right.
You always choose someone who's compassionate and who understands what it is that you would prefer.
Right.
And so they would look to your other incapacity documents, which would be like a directive to physicians, which basically says when you want to have care and when you don't want to have care, when you want them to pull the plug, possibly, so to speak.
Yeah.
And so you get to decide that.
And alternatively, I guess, if somebody wanted pull the plug right away, you'd want somebody maybe a little less compassionate.
Well, okay, so the documents that we prepare are directive to physicians. They are instructions. They basically say if I am sick and I have a terminal illness and but I'm conscious, I do want or I don't want treatment. And then the other option is I am unconscious, I'm not going to recover, and I don't or do want to have treatment. So they get to make those choices. But the hospitals also have another document that we don't touch, and that's a DNR, right, a do not resuscitate.
Oh,
and
I
that
did not
one,
want to sign that one.
Exactly. Well, and they won't treat you if you sign that and you have a heart attack or whatever. In some instances, that's maybe a good idea because what they have to do to bring you back might be too traumatic.
Right.
For especially a person who's like elderly. And
Yeah.
I mean, they could crack your ribs or whatever they have to do in order to bring you back.
You love
But
the
yes, I do. Yes, I do. And I don't like to see people suffering. And as long as they understand what that means,
Right.
to not sign the DNR, I mean, that's their choice as long as they are competent to do that.
Mm-hmm.
But then if you look at the directive and if you're the agent for healthcare, then you look at what they would want and you help them make those decisions. So
it's always better, really, as soon as you turn 18 to have these documents in place in case something happens.
absolutely, because before 18, your parents are in charge and they get to make those decisions for you. But after you become an adult, someone may have to step in for you, and you want to make sure that they have the ability to make those decisions and they understand what it is that you would prefer. Even though it's kind of different for me, for an 18-year-old to actually make those choices is it's a little bit weird.
Certainly
But
the DNR would
the
be
DNR,
a
exactly,
lot.
it's a lot for.
But I think a lot of parents don't realize when your kid turns 18, the doctors won't talk to you unless you have these documents.
Possibly. I mean, it just depends. Sometimes you go to the hospital, and if you're the next of kin and someone is sick, they'll go ahead and talk to you. But where I'm finding the people who won't talk to you are the educational institutions. So let's say your kid goes off to college and they go to the hospital. They know this is a college student. They may or may not talk to the parents, even though the parents are the one paying the hospital bills and for the insurance and whatever. And so
That happened to me in
that's
college.
exactly.
I went to the hospital for the first time. Luckily, I had the incapacity documents.
Exactly, but a lot of people don't have that, and the parents don't understand that they need that. And it's that time of year; they're getting ready to go back to school or start college for the first time.
Halfway through summer.
Exactly. So it's a good time for people to consider having those for their young adult children,
Right.
and they are young adult children. I know that sounds like contradictory, but it's not.
No, but it's true.
It's true. Yes, and so along with that document, the directive. So we talked about the 2 powers of attorney and the directive. We also do a contingent guardianship for adults, and it sounds.
Explain that a little bit, because I know even our clients get kind of confused. They're like, "What? I don't need a guardian. What is this?"
Okay, so sometimes a power of attorney, for whatever reason, may not be accepted.
We had that happen.
We had that happen.
A
Yes,
client.
yes, because there was a scratch out and there was an institution that did not want to take it. Luckily, the person who was signing, the principal, that's the person who is signing the power of attorney and giving somebody agency or the ability to act for them, he was still competent and could sign a new one. But if you have a situation where they can't, then the only option is to go to court to get guardianship over that person. So this document that we prepare names who you want to be the guardian, and you can also name who you never want to be the guardian. So if you have someone in your family that you would never want to be in charge of you, then you want to make sure that you have this document in place and that you have their name listed as to never be your guardian.
I don't think a lot of people. I didn't even know that we could do that on that form.
Oh, certainly you can. Yes, you can do anything you want on there. You can say what you want.
Well, that's the beauty of estate planning too, is it's so customizable. And I feel like a lot of people expect it to just be so simple, one and done.
Well, there's always the option to go online if you don't have any resources to actually get something that's actually fits what you need for your life. Then there's always the option to go online and to find something or whatever. But as soon as you're able to get a customized one, it's probably a good idea because it will actually do what you want and have the results that you're seeking.
Right.
And also, if you're doing those and you don't have the benefit of someone explaining it to you, you may not even know what you prepared. So you go online and you're filling out this form. There's nothing wrong with the software. There's nothing wrong with that site. It's user error. They're checking boxes and not understanding what the boxes mean that they've checked.
Right.
And that's not, that's not horrible. At least they're trying. At least they're trying.
At least they're trying.
Right.
Yeah. Applause for that.
Right. And then another document that people need is a HIPAA release. Now, that is one that a college student really, really needs because it tells the people at the hospital or wherever they are that they can communicate with the parents or whoever they list on there. Right. Should they be unconscious or they need help or whatever, and they can tell them what's going on so they can better help that young adult make decisions or make them for them. So those HIPAA releases are really important because it's difficult to make healthcare decisions without the information, and you need all of it. So you can make an informed consent and informed decision on what needs to happen to help them. So those are, I think that's mostly of it. Did I cover all of them? Can I think of one?
You did financial power of attorney, medical power of attorney, HIPAA, advance directive, declaration of guardian. Oh, it's a great segue into our next topic, which is title transfer.
Oh, okay. Yes, absolutely. Okay, so this is some confusion that I've noticed this week in particular. When a person, it's been quite the week, when a person receives an inheritance or should receive an inheritance or they're in line to receive an inheritance, basically is what it is. Let's say, this is a good example. Grandma has property. We don't know where grandpa is. We don't know where he is in this, but just grandma. Grandma has one child. Grandma dies. Everybody assumes that the property goes to the child. No one probated anything. No one did a small estate affidavit or any affidavits of heirship. There was no transfer of the property to the daughter. Legally. Exactly. So in the real property records, it still has grandma's name on it. Then the one child has several children.
Oh no.
Okay, so they get married. Those children possibly get married and they have children. The spouses of those children don't inherit it once their spouse dies. It's the separate property of the children of their mom. The mom, okay, so grandma, the mom, and then the children. It is separate property. Anything that you receive through an inheritance, anything through devised descent or gift devised of descent is separate property, and it remains that way. So the spouse dies, who owned the property, who received it from their mother, or should have received it, because nobody's ever done a transfer.
We still gotta go back to grandma.
Exactly, right? So it's not ever really been legally transferred, but everyone's assuming that this just happens automatically, and it does not. So it belongs. The title is still in grandma's name.
Well,
so
if all those people die, who signs?
Well, exactly. All of them die. Then they have their children who are then in line to receive it. So they have to work their way all of that way back up with, affidavits of heirship, but you have to find everyone. And if you don't know who everyone is, there's no way to completely clear that title.
And in this situation, would we need birth certificates to prove heirship?
Possibly. We might need birth certificates. We might need death certificates. Obituaries help. We've seen this. Exactly. It's a lot of stress. So you go digging. It's a lot of work. And so if your property is not worth much, then it's not worth doing all that. So
at that point, what happens? If nobody ever clears it, they just maybe say abandon the property.
Okay, so then property taxes are due. Nobody's paying the property taxes, and the county where it's located will probably sue all of the heirs. They will find the heirs and sue everyone for the taxes, and if they don't pay them, they sometimes will just take the property and sell it. They auction it off and get their money. Exactly. And sometimes they can do it two ways. They can do it either in rem, meaning for the thing, or they can sue you personally. If they sue you personally, then unless you pay it, that debt becomes a lien on your property. So if they do it in rem, that means they're suing for the thing, which means the land itself. Then I would just ignore it, let it go, because otherwise I'm not sure how you resolve it. I think, if the county has done the work, which they can, and they have found everyone, then possibly you could retrieve it from them. But you make a mess. There's a mess made every day when people die and no one transfers property, because in their mind, this is the way that it should go. It goes from grandma to the daughter, then the daughter's children, and then the daughter's children's children, and everyone believes, and some people believe to the spouse, but it never crosses over to the spouse unless there was a document from the person who actually had as their separate property that transferred it in a will or a trust or whatever to their spouse. That's the only way the spouse is going to receive that.
Now, in Texas, we're a community property state, so if they maybe bought a property together, that would be different, right?
That's different, right? That's totally different. But if you inherited it or should have inherited it, so anything by gift, devise, or descent is the way that it states. And that just means that you either somebody gave it to you as a gift, or you got it in a will, or you should have received it if they had transferred exactly in intestacy or something. So that's basically that.
Now, there are some people who don't have enough to need to probate. What's the difference there?
Well, it just depends what they're trying to transfer. So sometimes they're needing to transfer funds out of a bank account or something like that, and maybe there's no real property. So you could do, some banks will accept a small estate affidavit. They prefer that, and I do too, because a judge signs off on it and agrees that these are the heirs. There's an affidavit of heirship that you can use, but I don't think they're as favored, and that's because the judge never signs off on it, but witnesses are swearing to it. The small estate affidavit, they do that as well. They're swearing that we believe these are the heirs or whatever, but it's just individuals, and they are affidavits, and they are notarized, under penalty of perjury and all of that. And some people, I've seen people refuse to sign it because of that. They're like, well, I don't want to sign that because I don't know. It says I could go to jail if I sign this, and it's not true. And I know it's not true. So, exactly. So I've had people refuse to sign it, and I'm thinking, well, I guess you don't really know this information.
Or you know that it's a lie.
Exactly, one of the two, and I'm not sure. I'm not going to question them exactly, right? So, yeah, that's...
So, and in a small estate affidavit, all of the heirs have to sign.
All of the heirs have to sign, and that sometimes can be a problem if you have an heir who's... They don't get along, they may be fighting, and so all of these are reasons why you need an estate plan.
Truly.
You can avoid all of these problems. Exactly. And not only that, you also have the possibility of your estate, you can lose assets to the state, or assets go into unclaimed property. And currently, the state of Texas, there's $10 billion worth of unclaimed property. It's mostly cash. Land doesn't usually fall in there because the county usually takes it. Now, if the county takes it and they get more than they need to pay the taxes, they will put it into the registry, into the unclaimed property as well. I guess the amount, because if they can't find the heirs and the heirs are not responding and whatever, and they haven't claimed it, they can't hold on to that money. The money has to eventually go to the state. And I think is it 5 years? I think 5 years so if you have a bank account that you've forgotten about.
4 years to probate, and so the 5th year would make sense to...
Well, I guess so. I'm not sure if that's the reason why, but I know that there is a law that says that if you have it over a certain period of time, it has to be sent to the state. It's for the unclaimed property, and I'm not sure what they do with that money. I guess they earn interest on it. I have no idea. It's a lot of money.
Yeah.
So basically, if you don't want your property to wind up with the state and everyone losing it and not being able to get your assets, to receive your assets, then you want to make sure that you have a good estate plan, and you need to see an attorney to make sure that you have all of the documents in place. That's going to make it easy for your heirs to, or your beneficiaries, I shouldn't say heirs, or the people you want to have your property can receive it. So if you don't want the state to take your assets and you don't want it to wind up in unclaimed property, the best thing is to have a good estate plan and to make sure that you have a list of your assets so your family can find it.
And that's the T. I like that one better. Yay!
Okay.
It's a wrap.